Lordship. My lord, I am an assistant matron. My juniors have been promoted in the year 2016. I have been denied. It may only be listed day after tomorrow.
No. Before 21st, 22nd, not possible. You can take it on 22nd. 22nd January. 22nd, yes.
May I please, Mulot, on Mulot admission matter regarding Mulot compulsory appointment Mulot. May I period list?
No listing before 22nd. So
22nd.
choose your date.
Let it be on 22nd. Obviously.
May I pray before Lordship? Early item number 28 may be adjourned for the day, my lord, because our Mazumdar is newly engaged advocate after vacation maybe.
It is submitted at the bar that a new arguing counsel has been engaged in this case on behalf of the writ petitioner, and therefore the matter be adjourned for 3 weeks so as to enable the learned counsel to prepare and argue the matter. Since the pair is not opposed, same stands allowed that this matter be listed for hearing accordingly.
Masum.
May it please your lordship. Lordship, I beg to mention for listing a admission matter on 29th, lordship. Oblige, lordship.
Lordship, I beg to mention item number 27. With the consent of the other side, I beg for an adjournment for the demand.
Why?
Lordship, due to some personal difficulty, my senior could not prepare for the case today.
Oh, what is it? These are 2016 cases.
Lordship.
Then
And Lordship, the case was filed earlier by another advocate. And,
who is your senior?
Mr. Eshad.
Achha, we'll see. You be there when the matter is called up. If it is required to be adjourned, we'll adjourn.
Lordship, he is not present, my lord.
You remain present.
I am not carrying the.
Prayer is rejected.
My lord, item 19, with the consent of the other side, I have spoken to the senior counsel, BD Das, my lord, and my friend is also here. My lord, let this matter come after vacation. We are seeking adjournment today, my lord.
So sorry, basically.
We are seeking an adjournment, paying for an adjournment today, my lord.
23rd, my lord.
You are for the state
State, my lord.
with the consent of learned counsel for the writ petitioner, Mr. R. Dhar, learned additional senior government advocate, Assam 6, adjournment of admission hearing of this matter for 10 days. Considering the ground on which the prayer is made and in view of the consent of the learned counsel for the opposite party, admission hearing of this matter stands adjourned for 10 days, list accordingly.
On 23rd January, my lord.
After 10 days, it will come.
Interim order is there.
Interim order passed earlier to continue until further orders. Check it once. Yes.
May I, Lordship, with the consent of the other party, item number 15. In this case, we need to file an affidavit in reply, so we need 2 weeks.
Your name, please?
S. Dole.
Miss S. Dole, learned counsel appearing for the writ petitioner, submits that 2 weeks' time is required in this case for obtaining instruction and for filing rejoinder affidavit. Hence, the matter be adjourned for 2 weeks. Stop. Since the prayer is not opposed by the learned departmental counsel, same stands allowed. List accordingly.
Master Black.
May I please, Lordship. Lordship, I pray for listing of a writ petition, my lord. Matter pertains to the promotion of the petitioner, my lord. This matter came up before your lordship, and thereafter it was not listed because of this bench was not available. My lord has directed the state to obtain the instructions, my lord.
It's a part-heard matter.
Yeah, not a part heard, my lord. The notices are not issued, my lord, till now. Your lordship has heard the matter, but has directed the state to obtain the instruction.
And as part for motion.
My lord, it will come up for orders, my lord, or under orders column, my lord.
You say notice has not been issued?
No, my lord, only instructions were called for, my lord. Regarding the DPC has been held or not, that instructions was awaited, my lord.
So if no notice is issued, then it will be listed for motion.
My lord, but it has been earlier occasion it has come under orders column. It was last listed on 29/11, my lord. It came up under the orders column. And day after tomorrow, if possible.
24th Jan.
I'm obliged.
Motion item 1.
This is regarding appointment Anganwadi worker, my lord. Advertisement was made. I appeared in the selection. I was selected. Then, my lord, The DC Millard issued a Millard status report as per which
Mr.
Millard.
Rashid,
My lord.
from your synopsis, I could not make out any head or tail of what is your case. It's a fantastic synopsis you have prepared. So could you please tell the court what really is the matter?
Regarding appointment of Anganwadi worker, Millard. And 2009, Millard, there is advertisement. 7. And I appeared in the applied and appeared, Millard. I was selected is there, Millard. Then Millard, there was a petition against me, and that petition was withdrawn by the respondent, other party, Millard. So, Millard, I should be appointed there, but that is not, Millard. And the DC, Millard, still filed in submitted a status report to the higher authorities, Millard. That is when I have NSF page 46.
2009 advertisement,
My lord. 2007,
2007.
my lord.
2007 advertisement cannot be given effect to now.
But Millard, there is some delay, of course, Millard, but the Honorable Supreme Court has held that in Tarsim's case, Millard, if the third party is not affected, then delay may not be gone.
No, that's not the point. Third party is affected. Because by
But
now,
post is still didn't be vacant, Millard.
maybe, but there can't be a mandamus to give effect to the select list of 2007. Select list remain valid for 1 year.
But the procedure, and last Millard, I appeared in this case, another case, Millard, by the same party, Millard, page 61, the Honorable Court, Millard, held that the regarding Millard, certificate of the order, it is further provided that the no pre-advertisement for the post of Anganwadi worker in respect of number so and so shall be made. That is there, Millard, by the Honorable Court, Millard. And against which, Millard, I filed a petition as a contempt case, Millard.
Once you finish, please listen to the query.
Well,
If you cannot answer it, I'll close it right now.
well, I'll try.
A select list remains valid for 1 year
1 year, yes, right.
unless it is extended by an order of the court. Was the select list extended?
No, there is no such.
Then it has expired and no appointments can be made on from that. That's the law. You are free to argue and convince the court that that is not the law. Otherwise, there is no point entertaining a writ petition in 2024. So we will close the matter as simple as that.
It come on Friday, Millard, I'll take instruction and then your lordship will pass order.
Why Friday, tomorrow? All right, day after tomorrow. On the prayer of the stay, Rashid.
That may be.
Huh?
Day after tomorrow maybe, Millard.
Stay, Rashid. Have you understood the query of the court?
No.
The select list has lost its,
I am. Millard.
it cannot be given effect to now. That's the
Now,
law.
1 year is life of the selection, but some process or cases is going on.
There the court has to extend it. The
But
court
there
will
is
have
no
to
such
extend it.
order by extension.
Then nothing.
That
can
is
be done.
my knowledge is there.
Then nothing can be done. On the prayer of Mr. Rashid, and counsel for the petitioner, this matter stands adjourned and shall now be listed again for motion on the after tomorrow give the date.
I conclude.
My dear lordships. My lord, the petitioner is appointed on 1/4/2006 as peon, my lord, under Binakandi Anchalik Panchayat in the district of Bhojai, my lord. But there, initially they have approached this honorable court, my lord, and this court give a direction for verification, my lord. Accordingly, verification was done, and the petitioner name along with one another, my lord, was found, my lord, is a genuine, and accordingly submitted before the, my lord, so, my lord, before the commissioner PNID, my lord. My lord, thereafter, they have sent some names, my lord, which were only, my lord, it is called, my lord, pre-FRBM. Lordship may kindly see page 35, annexation 9, my lord. They have sent some name before the finance department, my lord, which is, my lord, from the headline, it is revealed that only for, my lord, pre-FRBM, my lord. Whereas, my lord, this honorable court, my lord, in Upenda's case, my lord, there is no made distinction between pre and post, my lord. And
So your client is seeking the benefit of minimum scale of pay
yes, my lord.
as per Upendas.
Upenda's, my lord.
Notice may be issued, my lord. I'll take instruction.
All right. But Mr. Giudice, learned counsel for the writ petitioner, peruse the amendments made in the writ petition. The petitioner is working as a, he is retired from service.
No, my lord, no. 17 years, my lord.
Petitioner is working as a daily wage
Yes.
earning peon.
Peon, yes, my lord.
And under the establishment of
মানে বিন্নাকান্দি আঞ্চলিক পঞ্চায়েত আন্ডার হুজাই জেলা পরিষদ।
Pinnakandi Anchalik Panchayat under Huzai Zilla Parishad. The grievance of the petitioner is that although he is similarly situated as the other casual workers who are entitled to the benefit of minimum of pay scale, within force, minimum of pay scale. As per the unquote, as per the decision of this court rendered in the case of State of Assam versus Upendas, reported in 2017, bracket close 4 GLT 493, no such benefit has been extended to him till today. Hence this writ petition. Full stop. Mr. S. Datta, Learned Standing Council PNRD Assam and Mr. P. Nayak, Learned Standing Council Finance Department have prayed for time to obtain instruction in the matter. NOM 6 weeks since Mr. Nayak has accepted notice on behalf of phone number 2 and Mr. S. Datta for the remaining respondents. Service of notice is deemed to be complete in this case. Extra.
I'm for 1, 3, 4, 1, 3, 4, 5, and 6, my lord.
Why not 7?
7 is my lord,
The chairman, my lord.
chairman, president, elected man. I can't appear, man.
And 1 to 1 and 3 to 6. Service of notice on the said respondents is deemed to be complete in this case. Extra copies of the writ petition be furnished to the London Departmental Council. Requisite in numbers so as to enable them to obtain instruction. Petitioner to take steps for service of notice upon respond number 7 by registered.
7 and 8. 7 and 8.
7 and
7
8.
and 8 by registered close.
Hello.
Item 3.
These are covered matters.
And
Will be
only,
ordered.
my lord, item 3 and 5 is for grade 4 post and 4 and 6 is grade 3, my lord.
3 and 5 grade 4 post, 4 and 6 grade 3.
Grade 3.
Give the order, give the.
7099 of 2023
Appearance.
for appearing.
All disposed of.
Obliged.
Item 7.
Similar order is there, no?
Please, your lordship will be filing an additional affidavit today, bringing on record the representation filed to Housing and Urban Affairs as well as the Finance Department. Lordship may take up this matter after 3 weeks.
Ms. P. Gupta, Learned Counsel for the petitioner, petitioner applicant raised for and is granted 3 weeks time to file an additional affidavit bringing on record the representation submitted by her client demanding compliance of the court order. Mr. S. Bora, Learned Counsel is present on behalf of the sole respondent. Let the matter be listed after the additional affidavit is broken.
Much obliged.
For admission, item 8.
May it please your lordship. My lord, in this case, petitioner is claiming the benefit of old pension scheme because, my lord, initially they were appointed in the year 2001, my lord. They have passed all the tests, my lord, physical, medical, everything. They were given the post number and they were, my lord, sent for military basic training. After, my lord, some days, my lord, suddenly, my lord, they were declared physically unfit, my lord, and they were without giving any show cause, nothing, my lord. Suddenly they were discharged from service. Then they approached this honorable court, my lord. Honorable court given a direction, my lord, to conduct appeal medical board, my lord. And in appeal medical board, my lord, they were declared fit. But due to overage, again their candidates are rejected, my lord. Then, my lord, again they approached this honorable court. And with the honorable court interference, they were appointed in the year 2015. Our prayer is, my lord, as we were initially appointed and we have passed all the tests, my lord, we were given post number. So we may be given the benefit of, my lord, old pension scheme, taking our date of appointment in 2001, my lord. And in my affidavit in reply, my lord, I have given some judgment, my lord. Similarly situated persons were given, my lord, same benefit, my lord. I have annexed that document.
Lordship, my senior is in Lakes, lordship. After some time,
All right. Who is your senior?
Mrs. A. Gayan, lordship.
Let her come.
Item 9.
My lord, on 15/12/2021, the petitioner sought time to file their reply to our affidavit in opposition. Otherwise, my lord, our stand was that the case of the petitioner could not be considered under the then prevailing scheme of compassionate appointment, as he did not satisfy the two criteria which were required for compassionate appointment at the time. Firstly, that the employee should have been killed during the extremist violence, or secondly, due to an accident or mishap while on board duty. Since, as per the admission of the petitioner, the father died while in harness, therefore we could not process the claim of the petitioner because he was not eligible as per the compassionate appointment scheme. That is our stand.
Who is for the petitioner?
Mr. A. Das, my lord, is
Is not present.
not present, my lord.
Take down, none appears for the writ petitioner when the matter is called up. Mr. A. Barua, learned SCA PDCL, is present and submits that although time was taken on by the petitioner's counsel on 15/12/2021 for filing rejoinder affidavit, no such affidavit has been filed till today. Full stop. Record confirms the said submission of the learned standing counsel. In view of the above, this matter stands adjourned for 4 weeks so as to enable the
Yes.
petitioner to appear and argue the matter.
I have come late. What type
You are
exam?
late.
Item
You are
9.
present, you are not late. Huh?
Item 9. Admission.
What do you want?
আজি ফাইল কৰিম
Huh?
ৰেডি কৰিছো ফাইল কৰি দি দিম
He says he'll file it today, the reply.
No, but you are appearing as a counsel,
yes my lord
but you don't have your band on. You can't appear like this. You leave the
sorry my
court.
lord sorry my lord
Yes, you leave the court. You file it. You have passed the order, you file it.
Please.
4 weeks adjournment, yes.
I'm obliged, my lord.
Item 10.
Lordship, after some time.
What is the matter? What is this case?
My lord, the petitioner applied for the post of Halda clerk in Assam Rifle, my lord. And they have passed the written examination, each and everything. But in final selected list, my lord, their name has not been come.
No, minimum has not come where?
In final selection list, my lord.
Hmm.
And after the scrutiny, it was found that the marks has been scored less. That candidate has been selected, and the
Is it
petitioner
the
has
covered matter, covered case, one of those cases?
my lord.
Huh? You don't know.
No, my lord.
Then if you don't know, then we'll adjourn it.
After
Petitioner
some,
has come.
Mr. Mazumdar will lead this matter, my lord. After some time,
When you want time, then you must ask for it in the beginning.
my lord.
Why are you banking on her? Fast over.
Deep your lordship.
Item 11.
May please, your lordship. On 7/11/2023, the respondents were directed to bring the communication regarding the termination order. What has happened?
Your lordship, this order though reflects about the termination order. While the matter was going on, it was with regard to the notices that were served prior to the termination letter. That was my understanding of the court's view. My bad that your lordship, I didn't go through this order. I've got the records with regard to the notices that were issued prior to the termination. This is a case of deemed resignation because of unauthorized absence from service. Termination notice, we have also issued paper publication. Those are there in our affidavit in opposition. At page, but I didn't get this record. Can I take some time then, your lordship, pray for 2 weeks time to.
Yes, lordship. Lordship, otherwise, he is not getting any pension, lordship, and early death, lordship. I may pray for an early death.
Mr. B.P. Bora, learned counsel is present for the petitioner. Mr. D. Senapati, learned counsel appearing for the respondent numbers 2 to 9 submits that due to oversight, the complete record as called for by this court could not be obtained by him. Mr. Senapati, therefore, 2 weeks further time to produce the record. Considering the nature of issue involved in this proceeding and the urgency expressed by the petitioner's counsel by submitting that his client is not getting any pension, this writ petition is directed to be listed again on 30th of January 2024 as a
Your Lordship, can it be on 6th of February? Let me help you to get the record.
Then what is it? Tell you. We are also entitled to know what you are deciding, both of you.
No, I'm just a request of, since I won't be there on 30th January, 6th of February, if it can be fixed, Your Lordship.
Where are you going?
Your Lordship, I have a matter in Delhi. I understand it.
You have matters everywhere, all across the country, huh? 6 February, all right.
Much.
Lordship, in this case, I am seeking accommodation for only 1 day, Your Lordship, because I have gone through the record, but not clearly, I have not gone through, I missed the matter actually, Your Lordship, on the last occasion.
What is the matter about?
DP, Your Lordship, department proceeding of a police personnel, Your Lordship. He was accused of some harassing a particular woman constable.
What is the penalty imposed?
Penalty
What
imposed.
is the penalty?
Lordship, increment, so Your Lordship.
Dropping one increment with cumulative effect, my lord. What had happened in this case, my lord, out of the same incident, criminal as well as the departmental proceeding was instituted against the petitioner, my lord. Subsequently, before completion of the departmental proceeding, in the criminal case, he was acquitted, my lord, from all the charges. And the charges in the criminal proceeding as well as in the departmental proceeding are the same set of allegations, my lord. And the witnesses, which has been examined in the criminal case as well as in the departmental case, are of the same, my lord.
So,
On that basis, my lord, as per the judgment of the apex court, my lord, in GM Tank case, my lord.
what does it say? GM Tank case, what does it say?
My lord, it says that if the departmental proceeding and the criminal proceeding are the same set of allegations, my lord, then if he honorably acquitted in the criminal cases, my lord, the departmental proceeding or the findings or whatever may be, my lord, that should go, my lord.
Show me the judgment.
Yes.
Which is the relevant paragraph?
My lord, relevant paragraph is at page para 30, my lord. Para 30, my lord. The judgment relied on
Mr. Hazarika, you please check whether this judgment has been followed in subsequent decisions.
Lordship, the GM tank. Please. Also, here also, Your Lordship, one thing there, one of the statement here was that in Placitum F, Your Lordship, para 30, the investigating officer, Mr. B.V. Raval and other department witnesses were the only witnesses examined by the inquiry officer who were relying upon the statement. So it seems that they were absolutely the same witnesses were examined, Your Lordship. Here, it is apparent that there were some other witnesses also in the inquiry proceeding, in the departmental proceeding, Your Lordship. At least there is a slight distinction on this point alone, Your Lordship. And I'll check, Your Lordship, if this process.
Because, though the Supreme Court decision is binding, but Supreme Court has observed that standard of proof is different.
Different, Your Lordship.
In a criminal trial, it has to be beyond reasonable doubt.
Lordship.
Whereas in a departmental proceeding, it has to be preponderance of probability.
Lordship.
Therefore, on principle, I'm finding it little difficult to understand. But then this is the finding.
Lordship.
So just check whether this decision has been followed subsequently and whether it is still good law or whether it has been.
One of the latest judgment, 2023 SCC online, following by this judgment.
What is the party's name?
Party's name is Ramlal, appellant versus the state of Rajasthan.
This has been reiterated.
Yes.
All right.
In that case, the standard of proof in criminal case and the departmental proceeding, that has also been discussed, because the vital witnesses in the departmental proceeding and the criminal proceeding are the same, basing on which the findings has been taken by the inquiry officer.
So do you have a list of who are the witnesses in the criminal case?
Yes.
Have you prepared a list?
Yes.
Have you given it to him? Have you given it to him? Have you prepared a list?
Lordship, so far as that.
In the criminal proceeding, 4 witnesses has been examined. That is one of the informant.
All right, he wants time. We'll have it on 30th.
Yes.
As a fixed item.
Yes,
Mr. Islam Learned Council is present for the petitioner. Mr. C.S. Hazarika Learned G. Assam submits that he has just received the records and therefore be permitted some time to examine the records before making submissions in this case. Taking note of the prayer made by Learned G. Assam and as agreed to by the parties, let this petition be listed again on 31/2024 for admission hearing as a fixed item.
31.
30.
Also, just one humble request, Lordship. I have already received the record earlier. So if it is reflected that just now I have received, it may seem like as if I
received the records.
Much
obliged, Lordship.
May it pleases you, Lordship. The petitioner was the liquid plumber, Your Lordship, and he was terminated Your Lordship, by showing cause he is unsatisfactory in training period, Your Lordship. And here, Your Lordship, I am challenging the impugn order dated, that is 21/4/2021, annexed as Annexure 7, that page number 33 to 34. Your Lordship, here is my humble prayer is, Your Lordship, as they have not followed the SOP, Your Lordship, that has been, Your Lordship, published by the Assam Rifle SOP, by not providing him enough time, Your Lordship, to improve his last PPT, that is physical proficiency test, Your Lordship. He has completed BPET, Your Lordship, that is battle proficiency test, and thereafter, Your Lordship, one test is remaining, Your Lordship, that is PPT, Your Lordship. That is that could not be able to complete, Your Lordship, because he has not provided enough time, Your Lordship, to improve his PPT test, Your Lordship.
Just a minute, please take your seat, just a minute. And So where is his appointment order? Where is the order of appointment?
Yes, your lordship. His appointment, provisional appointment is on page number 30, your lordship, annexure 4. Page 30. Issued on 19 November 2019.
So what is your case?
Case,
It's a
your lordship,
provisional appointment.
the provisional
He
appointment,
was
your
found to be unsatisfactory, so.
Your lordship, there are 3 relegation is there, your lordship, under training, recruit training period, your lordship. And he has not getting his enough time, your lordship, because I'm taking your lordship.
You are appearing in this
their
case
affidavit.
alone or you have a senior in this case?
No, your lordship.
You are appearing in this case?
Yes, your lordship.
So law is against you, what to do?
Your lordship, their submission, your lordship, SOP, they have given their own SOP, your lordship, that has annexed by their affidavit, filing their affidavit, your lordship, that is on page 15, your lordship. And your lordship, they have also annexed one annexure, your lordship, pointing it that similar matter, your lordship. And that is, your lordship, on page 12, your lordship. I would like to take you to the page 12 of their affidavit.
Yes.
He was enrolled as rifleman, your lordship. And your lordship, final judgment, your lordship, at page 14, your lordship, point 8. As the petitioner failed in BPET test 4 times, your lordship. He is being as a rifleman, your lordship. He has appeared BPET, your lordship, battle proficiency efficiency test, your lordship, for 4 times. Whereas my petitioner is a recruit plumber and he has appeared for 3 times, your lordship. For as a equity, your lordship, equity relief, your lordship, kindly grant him one last chance, your lordship, because here, your lordship, 4 times has been provided to the earlier petitioner, your lordship. In this case, your lordship, that has annexed by them, your lordship, in this affidavit. That is page 14.
You see, these matters are to be decided on the basis of established principles.
Yes, your lordship, principles
Listen. This is not a darbar of a empire that you can just give whatever you want. What they have done is permissible under the established norms of service jurisprudence. It appears that you are not aware with any of those principles. So you are just arguing like, give me. That doesn't happen like that. So you have any authority which supports your case?
Your lordship, their rules, your lordship.
No, I'm asking for authority. You will not have it because there is no authority which will support your case. So under the circumstances, you have only one chance to make yourself conversant with the law and then take an order, or take an order without being conversant with the law. Beyond that, nothing can be done. These are not in the gamut of the court, whether 1 more chance, 2 more chance. The court will only see whether they have done something which is arbitrary and in violation of the statutory rules. That's all.
Your lordship, I would like to take my petition, your lordship, that is on page number 45, your lordship. Their rules, Assam Rifles rules. And that is 21 of their rule, subclause 2. Page 45, annexure 11. I had annexed 1 extract part, your lordship. Extract copy, your lordship. That is 2. To discharge from services on grounds of unsatisfactory progress in training. That is subclause 2. In all cases of recommendations for discharge of a person, the commandant of the training establishment shall establish clearly the fact that the person has been given suitable warning and suitable time to show progress. Documentary evidence to this effect shall accompany the recommendation, your lordship. Here, your lordship, SOP also says that your lordship 23 weeks, that is multiply into 3, your lordship, that is 60.
So your case is your client was not given any warning.
No, your lordship, and your lordship sufficient times he has in his hand. But without that, your lordship, he was not providing enough chances, your lordship, to improve his PPT test.
When was his training scheduled to end? When was the training supposed to end?
Lordship, in this, actually, Lordship, in this case, Lordship, 40 weeks, within 40 weeks, the entire training has to be finished. And on 44th weeks, the attestation has to be done, Lordship, that support, Lordship. That has to be done, Lordship. It is for the persons who completed the examination from the very beginning, phase-wise, Lordship. And in this case, Lordship, person who fails in first attempt, he will be given 3 attempts, given 3 chance, 3 attempts. And again, he will be given a last chance as a final chance. In that case, Lordship, a show cause is to be given, Lordship. In this case, Lordship, entire procedure has been followed, Lordship. He has been given first attempt, Lordship, on 4/6/2020. Thereafter, Lordship, he appeared on second attempt on 5/1/21. Third attempt, Lordship, 10/3/21. Thereafter, he has been given a show cause notice that you are the last. This is the last chance, and that is that has been given show cause, and he appeared in the final attempt. In that attempt also, he failed, Lordship.
Where is the show cause notice?
Lordship, at page 74, Lordship.
Then why is she saying he was not given any warning?
Your lordship, taking to their affidavit, your lordship, page number 16.
27, 74, running page, Lordship. Show cause notice, Lordship, and except for, Lordship.
Yes.
This is the, Lordship. First attempt, second attempt, third attempt, he failed, Lordship. Thereafter, point number 3, Lordship. You are hereby warned to improve your performance to clear PPT test by 7th April 2021, failing which action will be taken against you for discharge from service. This is the last warning letter, Lordship. And again, he failed, Lordship.
So he has received this notice. There is
Lordship,
no dispute.
Lordship,
about
Lordship,
it.
Lordship. He is received. His signature is the,
You
Lordship.
take your seat. Yes, you are.
Yes, your lordship, I would like to take you annexure to your lordship of their affidavit, page 15.
No, but first, what is your case?
Yes, your lordship, he is not getting enough time, your lordship. Medical EME engineers, that comes under plumber.
What is the meaning of enough time?
Your
Enough
lordship,
according to whom?
23 weeks, that comes under 3, your lordship, that is 69 weeks. 69 followed, not followed properly, and then your lordship, 44 weeks, under 44 weeks, he has been discharged, your lordship. That's 69 weeks, your lordship.
Where does it say 69 weeks? Where does it say? Which rule?
Page 15, your lordship, annexure 2.
Page 15 of?
Their affidavit, your lordship, affidavit in opposition. Tabulation, your lord.
Yes.
Your Lordship, that is basic training equals to 23 weeks. That follows up 3 weeks each, 1 week each, Your Lordship. It was showing in their SOP. Page 16, Your Lordship, training of trade and five. Basic training, 23 weeks, followed by 3 weeks, and then Your Lordship, 1 week each, Your Lordship. So if we see, Your Lordship, then Your Lordship of 69 weeks not completed, Your Lordship, and beforehand, Your Lordship, on 44 weeks, he was discharged, Your Lordship. I have made one tabulation, Your Lordship. From joining date, Your Lordship, I already submitted it, Your Lordship, on the last occasion. Regarding the relegation time period calculation. His joining date is on 23/12/2019. Then training starts on 10/1/2020. Then first relegation, Your Lordship, start from 1/6/2020 and 4/6/2020 respectively, physical proficiency test and BPET, Your Lordship.
Is this the one? Is this the one you're referring to?
Yes, Your Lordship. Then Your Lordship, 23 weeks allotted as per the tabulation mentioned in
So
the
any
SOP.
allegation of malafide?
Apart from this, Your Lordship, none, Your Lordship.
So your basic case is that total training course spans to 69 weeks,
69 weeks.
but he was discharged on
44
completion of
weeks.
44th week.
44 weeks.
That's permissible. I thought he was discharged without any step-up notice. That has also been given. If the discharge is before the normal completion of training or probation and without warning, then the matter assumes a different color. You said there was no warning given to him, which was a wrong submission.
Your Lordship.
But he pointed out that as many as 4 show cause notices were given. 3 warnings and 1 show cause notice was given. That is sufficient compliance. That unless you allege malafide, there is nothing that the court can do about it. You are taken in on that terms. You knew the rules. The rules are not under challenge. So what can be done? There is absolutely no right.
Rules, Your Lordship, as they had Your Lordship annexed one annexure, Your Lordship, that is, he is a rifleman, Your Lordship.
Another 4 minutes.
And Your Lordship, he is a requisite plumber. If he has allowed only one chance, Your Lordship, they will have no loss, Your
I
Lordship.
would allow it as an individual, but the court is a different proposition. Court will have to go by the law. Is there any authority which supports your case? Any?
On the equity relief, Your Lordship, as being as a rifleman, he is getting 4 times, Your Lordship. One last chance may be allowed to him, Your Lordship, to improve, Your Lordship. Last PPT test, Your Lordship.
It cannot be done. Don't repeat this Because this court is not an appellate authority. It's to see whether the action is arbitrary or not. That's all. If the action is not arbitrary, that's the end of the matter. Otherwise, we will be running the Assam Rifles. We are not running it. Take down. Heard Miss EP Das Learned Counsel for the writ petitioner. Also heard Mr.
P.S. Locker.
P.S. Locker, Learned CGC appearing for the respondents. The order of discharge from service dated 21/4/2021 issued to the writ petitioner is under challenge in this writ petition on the ground that the same has been issued in an arbitrary manner and in violation of the SOP, Standard Operating Procedure, bracket SOP of the Assam Rifles as emerging from the Assam Rifles. This is Assam Rifles rules.
Assam Rifles rules.
Assam Rifles rules 2010. Is it Assam Rifles rules?
Rules.
Where is it? Show me the rule.
That Annexa 3 Lordship, page 73 Lordship. Of my opinion. Rule 21 Lordship.
Where is it written in print? You have written, handwritten it, Assam Rifle rules.
Yes, Your Lordship, I have annexed it in my
Yes.
annexure, Your Lordship. Assam Rifle rules, Your Lordship, annexure 11/45, page 45. 21 subclause 2.
I want to see the print of Assam Rifle rules. It's not there. As prayed for by Learned Counsel for the party. This matter stands adjourned for 2 weeks. List accordingly. Learn to start coming prepared to the court.
Lordship.
It's time the council should start coming prepared to the court. Yes.
Deeply obliged.
May it please your lordship. Lordship, matter pertains to compassionate appointment, my lord. We have challenged the rejection, my lord, page 20. Page 20, my lord. SLC have rejected the claim of the petitioner.
Page 24.
Page 20, my lord. Annexure D, my lord. May I read, my lord? I am directed to inform you that the state level committee SLC in its meeting held on 14/5/2020 has rejected your proposal for appointment under compassionate ground due to lack of sufficient vacancy post available under 5% quota for appointment under the compassionate ground.
So what is wrong with this?
My lord, I may be adjusted in any other department, my lord.
No, but in which department posts are available?
In
Tell
any
me,
other department in which vacancies are available, my lord.
who died? Petitioners?
Petitioner's father, who was working as account officer, my lord, died in harness on 7/1/2014, my lord. Several round of litigation, my lord, several round of litigation has been fought by the petitioner, my lord. My lord, petitioner is qualified, my lord.
Died
And
when?
7/1/2014, my lord.
So 9 years back, 10 years back.
Yes, ma'am.
They are entitled to compassionate family pension?
No.
Why?
After 1/4/2017, that is what the scheme says. Compact. Whoever dies after 1/4/2017.
So what do you have to say on his?
Your lordship, otherwise here, first and foremost, SLC is not made a party in this whole writ petition. They have actually challenged this particular order, but they have not made SLC a party. The minutes have to be challenged here. They have not challenged that minutes.
All right, these are technical.
These are technical issues. Otherwise, of course, the ground of immediacy in any compassionate appointment case, because the whole purpose of compassionate appointment is to tide away the financial crisis. But now 10 years have
Yeah,
elapsed.
but if there is an improper consideration, then why should the person be made to suffer?
Your lordship, otherwise, because here as per page 20, they say that 5% quota is not available. 5% vacancy quota is filled up, no other vacancy is available. So that his case was considered. And after considering his case, since there was no vacancy available, he could not be given any compulsory appointment. And now with the whole.
Yes, you have to show that vacancy was available on that particular department. Otherwise, we can't go for a witch hunt. Everybody will come and then we have to reopen everything and then go back 5 years.
Maybe there is no vacancy in that particular department, PhD department, my lord. Petitioner may be adjusted in any other department.
Which department?
In which vacancies are there?
Where the vacancy was there? Where? You have to make out a prima facie case. Otherwise, how does the court go for it?
Or I have a simple prayer before your lordship to remand back the matter to the appropriate SLC.
No, this is creating a havoc. This prayer can be granted somewhere else, not here. These are not giving anything to anyone. It's just creating tons of litigations, metric tons of headache for the department, and of course, some litigations for the members of the bar. That's all. What is the outcome of all these things happening? People dying 20 years back, 15 years back, compassionate appointment. Cannot be
My
done.
lord, petitioner have fought several rounds of litigation, my lord, hoping that he may be appointed under the
So
compassionate appointment.
that's what we'll bring it to an end today. So that he doesn't have to fight anymore. You can't, see, 5% quota is not there. That's the end of the matter. What can be done? Maybe there is some vacancy in some, so please send it back. That kind of orders cannot be passed.
They may look into it, my lord.
Sorry. You tell me in which department there was a vacancy at the relevant point of time. You show us that. Where have you stated it?
My lord may give me some time, my lord.
Tomorrow. On the request of the petitioner's counsel, this case again tomorrow as a first item.
I'm obliged, my lord.
Item 16.
Day after tomorrow, make it day after tomorrow, day after.
May it please your lordship. Lordship, I kindly pass over the matter for the time being, lordship.
No, why?
Lordship, I would require my senior to.
Senior will come, you argue.
Lordship, kindly for the time being, lordship, I would need assistance of my senior.
It is not going to be convenient for the court to pass it over for the time being. You either argue it or will post it on another date.
Lordship, in that case, post it on another, because I require my assistance, require assistance of my senior. Lordship, it involves the question of reservation in the PNRD department, lordship, junior engineer civil. We are saying that there is an excess reservation in the PWD category.
So why don't you argue? Start the argument.
In that case, lordship, I would say that if I require assistance of my senior, lordship would hear him.
Conditional argument.
Yes, lordship.
And the prayer of learned counsel for the writ petitioner, these matters stands adjourned for a week, list accordingly.
Much of. Lordship, interim order may continue.
Interim order passed earlier to continue.
17.
In this case, my lord, DLC recommended my name, but SLC has rejected my issue, saying that my lord, the balance service less than 3 years, and my lord, the application was pending more than 2 years.
Who died?
Father died.
When?
2015. And DLC recommendation, my lord, 2018. And 2019, my lord, SLC rejected.
So less than 3 years notification. has
Lordship,
been
kindly
sent.
adjourn the matter for 7 days, only 7 days,
What will
lordship,
happen
as the
after
lordship on the writ appeal was pending, lordship. And and one interlocutor of application was also pending, lordship, that was listed on tomorrow, lordship, for suspension of the order, lordship. 7 days time,
So
lordship.
you are taking adjournment in every case and
No, lordship.
division bench is not granting you any.
No, lordship,
order.
lordship, on the basis, on the rejection order, lordship, it has passed, lordship, his application
All right,
was
on 19th, on the request.
on 19,
of-
lordship.
Heard Mr. M. Mondal on the counsel for the writ petitioner, on the request of Mr. A. Chakraborty, Learned G. Assam appearing for the state. This matter is directed to be listed again on 19/1/2024. so as to give him one final opportunity to produce a copy of the interim order, if any, passed by the Honorable Division Bench in the appeal preferred against the judgment and order dated 30.
3245/18, Lordship.
Date of the judgment
Date of the judgment, Lordship, 31/23.
passed by the learned single judge in WPC number
3245/18.
3245/8.
Bless. Bless.
Item 80.
Regarding date of birth. There is some mistake in the synopsis, is it?
Yes.
Huh?
A mistake they have committed.
In the synopsis, there are mistakes.
Hello? Huh? Oh. The date of birth was synopsis 31/12/1962, my lord. And he was given retirement on 31/1/2022. 1 year ahead, my lord.
And he should have been retired on which date?
He was retired on 31/1/22, my lord, 2022.
That is on the basis of the date of birth recorded in the service book.
Your service book, as per the army retirement order, my lord, he was initially in army. And 2000, he retired from the army. Thereafter, he has joined in SPC on contractual basis, my lord. And as per the documents, Army then annexure 2, my lord, page 16. Army retirement date of birth was recorded as 31/12/1962, my lord. And according to the army has ASPC has recorded his
So he should have gone on retirement on 31/12/2022. But they retired him in the month of January.
1/1/2022. 1 year.
Where is the service record? Where is the service?
Lordship, we have stated in our affidavit, Lordship, in paragraph number 6, Lordship, during his service tenure, he has not filed any appeal, Lordship. Only after his retirement, Lordship.
No, the question is on what basis the entry was made in the service book?
On the basis of a PAN card, Lordship, that we have already annexed in our affidavit, Lordship.
PAN card.
Lordship, which the petitioner has annexed, Lordship.
No.
That is paragraph 5, Lordship. Running page 31, Lordship.
PAN card shows his date of birth is 31/1/62.
Lordship. That also. And he has already admitted, Lordship, in paragraph 6, page 32 of our affidavit, running page 32, Lordship. Mo- Lordship, moreover, the petitioner has already admitted in his voluntary retirement scheme application that his date of birth is 31/1/1962, and the said form was duly signed by him. Lordship.
Which page you are referring to?
Lordship, running page 32, Lordship, paragraph 6 of our affidavit, Lordship.
There is some mistake in the page numbering.
May
Running page 34.
Sorry.
This is SR8. As per SR8,
Lordship.
3 years within the date of retirement,
Lordship,
no
Lordship.
correction
Yes.
is permissible. Yes.
In their affidavit, they have given two PAN card, my lord. One is real PAN card and there is post PAN card, my lord. Your lordship, see the page 36 of their affidavit. It is the my lord PAN card.
Your client is holding a PAN card.
Yes, my client PAN card is correct. They have annexed two PAN card.
Where is the PAN card? Where is the original PAN card?
Original.
Both the PAN card has been submitted by the petitioner himself, Lordship.
It cannot be, my lord. Petitioner has only the original, my lord. I have annexed both the original PAN card and the Aadhaar card also. They are in my affidavit. They are 20. In my affidavit also, I have annexure A is the affidavit of PAN card. Annexure B is the Aadhaar card.
Now, can a person have two different PAN cards?
That is known, will be best known to the petitioner, Lordship, because at the time of his entry, he has submitted the earlier one, Lordship. Later on, after his retirement, he has submitted this one, and he has confessed that he was earlier employed in army, that he has never confessed during his service period, Lordship. That we have written in our affidavit, paragraph 7, Lordship. Running page will be 35, Lordship. He has never confessed that he was in army.
You have the service book. You have the service book.
Right now, I don't have something.
That is the identity card issued by the ASTC, my lord. After his joining, in that identity card, his date of birth was recorded as 31/12/1962, my lord. In the ID card, my lord.
In the VRS,
Was there a PAN card earlier issued where the date of birth was mentioned as 31/1/2022?
No, that is the post. Your lordship kindly see their affidavits. Their affidavits, my lord, that are 5/8/2020, one affidavits, my lord, page 35. Page 35, the copy, according to them, you see, lordship kindly see, there is no stamp paper. This affidavit, PAN card is pulled by them to show the date of birth as 31/1/1962. There is no stamp, and signature is also different. And next one, page 36, it is the real one. They pulled this document.
You get the service record. Who's the IT Standing Counsel Income Tax Department? Who's the SC for? Can you please request him to come for a minute? We'll find out what is happening.
Lordship.
If there is an FIR coming against either the petitioner or the departmental authority.
Lordship.
because one of them has played a mischief. So let's see who will be the receiving end of the FIR. We'll ask the SC IT department to verify.
Lordship.
And
Because in a BRS application also, he has stated that his date of birth is 31/1/1962, Lordship. That we have stated in running page 34, Lordship.
so, can you make a photocopy of that PAN card? Yes. Mr. Sharma?
That is there.
I
also,
have
Lordship.
annexed already.
In our
In
affidavit,
my
Lordship.
affidavit, I have
We have
annexed it.
annexed both the PAN cards, Lordship.
In my affidavit, I have annexed it.
All right.
Affidavit,
Both the PAN cards are annexed in,
Affidavit filed by the ASTC, Lordship.
T10 to Annexure A and Annexure B. Annexure A is the affidavit or PAN card. Annexure B is the Aadhaar card, my lord. It is, I have filed this affidavit on 3/10/2023. Page 46 and 47.
all right. So we'll get a verification done by the income tax department. Right. Please wait for a little while.
One thing I'd like to point out, my lord, in my affidavit, in my petition, I have annexure 4 is the ID card issued by the STC, where the date of birth was given as 31/12/1962. This is the ID card issued by the STC, my lord, on the basis of my documents.
No, what we want to find out is why there are two PAN cards with two date of birth.
One is forged then, they have.
That's what
Because-
the IT says is forged, the matter ends there. If the IT says is genuine, then you will have to answer. We'll find out what is the reality.
Yes, Lordship.
Clear by it.
PAN number is also same, Lordship. With same PAN number.
Same PAN number.
But date of birth, only the
same
difference of
person's
date of
two
birth.
Date of birth.
Lordship.
Let the
Your
IT
signature is different or no stamp in there.
Stamp is there, Lordship, that hologram.
But first stamp is not here.
No, hologram.
It is not here.
Mr. Kyle, sorry to call you here. We have a little situation here. And the court is seeking a little help from your department. See, we are hearing a matter where an employee has come before the court saying that he has been prematurely retired. According to the petitioner, his date of birth is 31/12/1962. Therefore, his retirement age on 60 years would have been 31/12/2022. But the department has retired him on 31/1/2022. That is almost a year ahead. Now, we have on record the statement of the department who says that he has given us a PAN card where his date of birth is recorded as 31/1/62. Based on which, so the long and short of the matter is there are copies of two PAN cards of the same person, same PAN number. One shows date of birth 31/1/62. One shows. You have
Yes,
shown it?
Lordship.
Yes.
Lordship.
31/12.
So we'll give you the copies of the affidavit. Do you have an extra copy?
Lordship,
of
I will
can you-
provide. I will.
Can you please find out which of the two PAN card is genuine or what is the story behind this?
That's it.
Because normally a person will have only one
Yes,
PAN card.
that is the rule of the department.
Yes.
If anybody has two PAN cards, he has to surrender one lot.
So was this man provided with two PAN cards? There must be some record of it.
But normally the person is to apply. And there is a.
And he has the original PAN card with him, which can you please show him?
I'll make.
That shows his date of birth as 31/12/1962.
I'll make it.
But the department says there is a PAN card.
Original. PAN card and Aadhaar card.
As well as in VRS certificate, VRS application also, he has
That
stated.
he will not be
Lordship,
bothered.
Lordship. PAN number to same, A2, sir, A2. A2, same. A2 color 31/12, A2 31/1. A2. Same.
Why don't you
constantly
take a picture of both this in your mobile and send it across?
Here quotas. But the number is same, lots.
Number is same, but the date of birth is different. Why don't you take a picture and send it to the concerned authorities?
Lordship, allow me some time,
How much time?
after vacation, Lordship.
We'll have it on 22nd.
Lordship.
22nd.
23rd, my lord.
22nd.
Second, I will be absent.
All right.
Get a copy then.
All right, Mr. Mr. K. Sharma, Learned Counsel is present for the writ petitioner, Mr. R.N. Das, Learned SC, Water Resources Department, and Ms. M.D. Bora, Learned SC, Transport Department, Assam, are present on behalf of the official registered to list this case again on 23/1/2024 as a fixed item by reflecting the name of Mr. S.C. Kyle, Learned Standing Counsel, IT Department, in the cause list.
Lordship, I am representing ASTC, Lordship.
Actually, you're, okay,
ASTC.
not water, ASTC.
Item 20.
My lord, instructions are short for my lords. My lordship will kindly accommodate me for one chance. Normally, my lord, personally, I want to accede to the prayer, but without an affidavit being filed, my lords. Because my lord, VRS was given, again taken back. After long delay, my lord, DP initiated. But without any affidavits on oath by the authorities, my lord, I find it difficult. Otherwise, I could have acceded.
GRS was granted.
Granted, my lord.
2012.
12. Rightly or wrongly, it was granted. Taken back.
2023, when I raised my grievance for pension, they were not settling it.
Permissible.
Let the affidavit come, my lords. Otherwise,
By when will you file the affidavit?
my lords, let me come in the month of February, my lords.
My lord, already more than 3 chances have been granted to them. Your lordship can see the records.
I know, my lord, that is the reason.
Is there any interim order?
There is an interim order in operation, my lords.
So let him have fourth and the final.
That your lordship will observe kindly.
That is the view special.
Otherwise, I was acceding, my lord. But this kind of matters, my lord, without
He
an
wants to
affidavit.
enjoy his view in peace.
My
Why you want to stop him? Heard Mr. S. Datta, Senior Counsel appearing for the writ petitioner. Mr. D. Gogoi, Learned SC Forest Department, submits that although adjournments were availed by the department in the past for filing affidavit, complete instructions are still awaited. Stop. Therefore, one final opportunity of 10 days time be granted to him for obtaining instruction and filing affidavit in this case. Taking note of the request made by the Learned Department Council, this writ petition is directed to be posted again on 7th of February 2024 as a fixed item. Affidavit on behalf of the department be positively filed on or before 2/2/2024, failing which this court will consider directing personal appearance of the concerned official.
My lord may also record presence of the counsel for Sikhs. My lord, they were also seeking time on this and that pretext. So
My
that
instruction is lordship
Mr.
department
R.K.
is here.
Talukdar, Learned Standing Counsel,
Respondent number 6, my lord.
appearing for the respondent, Learned Counsel appearing for the respondent number 6, submits that he has received instructions and will file affidavit on or before the next date fixed. List accordingly.
my lord, the interim order makes.
Interim order passed earlier to continue.
I'm being admission method, item 8. Motion method.
Yes, item 8, who is appearing? So you call serially, then we'll come back to item 8 again. Serially, you call.
For orders. Item 21.
Met please, lords.
Yes.
Well, review petition, well, for review of the order dated 3/10/2019, my lord. Passed in WPC number 2943, my lord. That is honorable court, my lord.
Hmm. Why the review of this order?
My lord, after similar order, my lord, some of the petitioners were approached the division bench, my lord. And division bench held that all the orders passed by the learned court, my lord, is retrospective in nature, my lord. In my case, my lord, well, allowing the writ petition, the honorable court has held that I am entitled to pension, not from the date of the retirement, but from the order passed in my lord Sanjita.
You have to get that clarification from the DB, not in a review court.
The review court has also.
Only a technical ground, I'll close it today. You have to file, you have
Well,
to say
in-
that grant me the same relief.
In
That's
my
it.
lord, BCCI, my lord, versus Netaji Cricket Club, it has been held, my lord. Court has the
Not
power,
matter. Why are you unnecessarily creating problem for yourself and your client?
my lord.
Get a file a writ appeal and get that clarification from the
That's
division
true, my
bench.
lord.
Then I think you should withdraw and file a writ appeal. That's for the appellate court to give the relief.
My lord.
Get it from the appellate court. It's not a ground of review.
Well, in
The
that
learned
case,
judge has made a mistake.
my lord,
How can it be corrected by the same bench? Review means the same judge is hearing the matter. Yes, I'm closing it. You want to withdraw or?
I am withdrawing, my lord.
Okay. You have understood the point. It's
My
a
lord.
matter of 5 minutes before the DB.
My lord.
I hear you'll have to argue for 3 days. I'll pose 5 questions to you. You'll take adjournment 5 times.
My lord.
Why you want to do all these things? There's a straightforward way. Had Mr. P.J. Sekel and counsel for the petitioner who seeks leave of this court to withdraw this review petition with liberty to pursue appropriate legal remedy as may be available to his client in the light of orders passed by the division bench in analogous matters. Mr. R.K. Talukdar, learned SC.
AG, my lord.
AG, Mr. P. Nayak, learned SC Finance, and Ms. E.S. Neo, learned Standing Counsel Irrigation Department are present and do not have any objection of the prior is allowed. The review petition therefore stands disposed of on withdrawal
With
with
liberty.
liberty as prayed for.
Now, let us-
First day you show the order and get the clarification, matter ends there.
No, there is no Supreme Court order, my lord, here.
Achha, you want to argue this review
No,
petition?
my lord.
You argue.
My lord. Now, let us-
You want to argue, you argue. I'm not forcing you.
Hmm.
But
I'm
that's not
withdrawing.
an error apparent.
That is
That's
not
a
there.
erroneous
That is not
judgment.
there. That's true. Now, let us-
Item 22.
May it please your lordship. Lordship, as per office note dated 5/1, my lord, shows that respondent number 3 and 4 appeared. And with regard to respondent number 2, my lord, it was deemed to be served, deemed to be complete, my lord, as per order dated 21/3/23, my lord. And regarding respondent number 1, it was awaited. And
Respondent number 1 is the chairman.
Chairman, my lords.
Lordship.
Otherwise, the order has been complied with, my lords. The APDC passes speaking order to that effect also.
Show it to her.
I'll just place that. Item number 23 is similar.
Ms. B. Bora, learned counsel for the writ petition. also
Lordship,
have-
would require one day time with, will take instruction from our client.
No, we'll go by the order. If it is
Yes,
complied,
my
it
lord,
is
but-
complied with. Your client and you cannot decide whether the order has been complied. The court will
Lordship.
decide. This is a contempt matter.
It needs to be verified once, my lord.
Yeah, we'll give you a time till 12.
Till 12
Verify.
months.
Yes.
Obli-
But please be aware, it is
Yes.
not a question of your opinion. The court will decide.
Yes,
whether
my-
the
yes.
order has been complied.
We'll just have
You
a,
can only point out any mistake,
yes, my lord.
not
We'll-
whether you agree or
Uh,
disagree. That's hardly of
yes,
any.
yes,
We'll take it up at 12.
at
23 similar,
also.
madam.
23 also.
24.
Wait, please, Lordship. I'm appearing for the Lordship, Secretary number 2.
Yes.
2 weeks time to file my reply.
What
Lordship.
is the order?
Order, Lordship, may kindly. Page number 11. Operative parties at page 12, paragraph 7. When a person is placed under suspension, the legal implication is that he would be debarred from performing his duties and be paid services allowance. But at the same time, it cannot be said that the other service conditions of the petitioner would also be kept in abeyance as because the employee have been placed under suspension. If the petitioner was not included in the list of beneficiaries of the payment of gratuity, it is for the respondents to pass urgent necessary order under correcting the same, and merely because his name was not included, the list of beneficiaries as because he was placed under suspension cannot be a reason to deprive him from the payment of gratuity. Accordingly, respondent number 4 being the Secretary of the Srimanto Sankardev Kalakshetra Society is directed to pass a reasoned order on the entitlement of the petitioner towards the pension of the gratuity in the light of the observations passed herein above. The reasoned order be passed within a period of 1 month from the date of receipt of certificate copy of this order. Mr. J.K.
You
Goswami.
are appearing for respond number 2.
Yes, Lordship.
Who is for respond number 1?
Last time, yes, M. Bhattacharya appeared. No, Lordship, may he done,
He is not present today. All right, we'll give him 2 weeks time to obtain instruction. But Mr. S. Borwal and SS Borwal and counsel for the petitioner. None has appeared for the respond number 1, although the name of Ms. M. Bhattacharya is shown in the cause list. Mr. R. Sharma and counsel for the respond number 2. Prays for and is granted 3 weeks time to obtain instruction and file affidavit that the matter be listed accordingly.
obligation.
Item 25.
Sir, actually, there is no contempt, my lord. Already, their candidacy has been cancelled, giving notice. They have challenged that by a second writ petition, my lord. So this is the non-implementation of the order of earlier writ petition. Already given notice. Earlier order is of 16th of November 22. Notice given on 14 December 22. Within 1 month.
Which is the order?
No, our contention is not that. Is
1 minute, 1 minute. Which is the order?
misrepresenting.
Where is the order in the court?
Is misrepresenting, my lord.
Order page 23 of the contempt petition, 1611.
We have not filed, my lord, contempt petition for this order, my lord, for violation of this order. Operative part, your lordship may see, look, paragraph 7, page 24. From paragraph
Part
7.
Page?
Page 24, paragraph 7. Operative part of this order is this one.
No, you are alleging violation of order date.
No, No, there is a thing, my lord. Here, in the,
On the request of Mr. Sinha, this matter stands passed over for 2 weeks. Mr. KK Parasil. I am asking you, what is the date of the order? You are saying no.
yes, my lord.
Yes, you
Yes.
enjoy your view and then come.
No,
back.
my
Just-
lord. Kindly look into my lord.
Next matter.
May it please your lordship, my lord. My lord, today IA has been come up for consideration, my lord. That petitioner has been placed under continuous suspension, my lord, without there being any review. And moreover,
When was he suspended?
yes, my lord. Suspension order dated 22/6, my lord, 2023. My lord, and my lord, he was initially arrested in connection of a FIR, my lord, 12/4/2023. Arrested on 12/4/2023. And the Honorable Court granted him bail on 24/5/2023. And individual, he was suspended on 22/6/2023. And after granting bail, my lord, he approached the authority by representation dated 15/9/2023, my lord, for allowing him to continue or for revocation of the suspension order. Since this is deemed suspension, he was placed under this suspension, my lord. And in between, after the representation file, my lord, they serve one my lord, memorandum search on 9/10/2023, my lord. That memorandum search has been, my lord, challenged before this honorable court. Therein, my lord, the memorandum search has been pleased to be stayed, my lord.
There is another writ petition pending.
This is the yes, this is the writ petition. Here I was arguing, my lord. IA for, my lord, for consideration my representation, my lord, for revocation of suspension in view of staying of the, my lord, DP. And there is no review of the.
Where is your representation?
My lord, page 34 in the IA, Annexure 8, my lord.
Mr. Nayak, there are some division bench judgments on this
Yes,
topic
lordship.
subject.
That is their lordship. But in the meantime, lordship, memorandum of service has already been issued to him in the meantime, lordship.
Right.
And his representation was on 2/6/2023. So his 3 months starts from that date, lordship. Within that period, lordship, memorandum was issued.
After 108 days, my lord, not within that.
From the initial date, it is 108. From the date of
So,
communication.
any decision of this court on that particular point?
Yes, lordship said if in the meantime no search has been issued, then department can extend the suspension by doing necessary review, lordship.
Which is, you have the judgment.
That is.
My lord, even, my lord.
Just a minute, Mr.
Sorry.
Das. When the court asks questions, you will not be able to answer. Therefore, you keep talking when there is.
Yes, that is original judgment, lordship.
Where is the Ajit Sanwal judgment? Have you seen it?
My lord, in fact, my lord, that
Have you seen the
I have
judgment?
not, sorry.
Then you cannot answer.
My lord, because on the basis of their own memorandum, I was, my lord, arguing, my lord, page 24, their memorandum.
Mr. Das.
This is on the
only
basis.
Order that the court can pass is posted another day, so that you come prepared with the Ajit Sanwal judgment. Without knowing the judgment, how are you going to argue on law points?
My lord. Even
This aspect of the matter has been dealt with in the judgment.
Yes. Even in the Ozoy Kumar Sodhuri case, my lord, one thin line is there. If they want, even if search is given, my lord, if they want to continue with the, my lord, suspension, there should be some review. My lord, this is the judgment, my lord, just one, and their, my lord, office member, page 24. Here also it is
All right.
if.
Yes, you argue, you'll argue. We'll pass an order on the basis of Ajay Sanwal, because Ajit Sanwal, because there the law is against you. You don't want to even argue on that. You don't want to look up the law.
For our lordship, I pray, my lord, page 24, just once, page 24 of the IA, my lord. This is their office from memorandum, therefore I was submitting, my lord. 4th of February 2020, it is on the basis of this writ petition and Ozoy Sodhuri case, my lord. This has been issued. Second para, last 3 line, my lord. If the memorandum of charges, public charge sheet is served within 3 months of suspension, a reason order must be passed for extension of the suspension whenever necessary. Well, even if, well, firstly,
All right, Mr. Nayak, you get written instruction, we'll post it on 18, whether any order has been passed
Yes.
extending his period of suspension.
Yes, Lordship, reviewed or not, Lordship, yes.
Mr. B.K. Das is present for the applicant on the request of Mr. P. Nayak, Learned SC. You have for the finance department.
Yes, Lordship, 1 to 4.
And SC Finance Department appearing for response numbers 1 to 4. This matter is directed to be listed again on 18/1/2024. So as to enable him to obtain specific instruction and ability this court as to whether the order of suspension of the petitioner applicant has been reviewed. And if so, whether the same has been extended by a specific order passed by the competent authority. The instructions be placed before this court on the next day fixed. List this case again on 18/1.
Lordship, may kindly make it 19, Lordship. 18 is reopened, 19.
19.
Lordship, I appear for respondent 5.
Mr. Borthakur, Learned Counsel is present for the respondent number 5. Let him get that. You check the judgment.
Sure, my lord, sir.
When the court says there is a judgment, you don't care to even.
That's not the approach.
This is not the way to argue cases.
Mala, in the writ petition, Mala, interim order may be continued 16/10/2023. In the writ petition.
It is till today.
Mala, yes, ma'am.
Till next day, yes, Lordship.
In the writ petition, you read hand Learned Counsel for the party. List the case again on 19/1/2024. Interim order passed earlier to continue. Yes. Yes.
I had two matters, 22 and 23, wherein the respondent government has submitted that they have complied with the order. We're very much happy with the order, but I have not received any instruction from a client. Moreover, in the order, there's no reference of my case number. So there's a predicament here.
No, it's not that.
Yes.
If the order has been complied with,
Yes.
we'll record it and close it.
Yes, my lord, that may be done. Yes.
So you write
22 and
item
23.
23 and 24, Ms. B. Bhuyan and senior counsel assisted by Ms. B. Bora is present for the petitioner. Mr. B. Chaudhary, Learned SC, APDCL.
Appearing, my lords, for contempt petition.
Mr. B. Chaudhary, Learned Counsel appearing for the opposite parties. Has produced a copy of the order dated
12/2023, my lords.
2/12/2023 to submit that the order of the court has been complied with insofar as the writ petition has a concern. And therefore, this proceeding be closed. By retaining, in view of the submission made by Mr. Chaudhary, by retaining a copy of the order dated so-and-so in the record of this case, this contempt case stands closed. Same order in the other one. If anything is found to be wrong, there will be serious consequences.
Mine.
So you don't have to worry.
Lordship, deeply
Yes,
obliged.
Lord, Doctor.
Please, Lordship.
Yes, why on time in this case?
Lordship, we will file an additional affidavit for some material facts has come to light, new facts has come to light, ma'am.
What fact?
The petition, we have called the petitioner on next Sunday. He will come and give us instruction for filing an additional affidavit.
I'm appearing as CLC, my lord, B. Sharma.
No, that's all right, but this challenge is against what?
My lord, removal from service, my lord. He is deserted the my lord, camp, my lord, for 3 times, my lord, 3 occasions, my lord. In the earlier occasion, without any permission, without any authority, my lord, he has left the my lord, camp, my lord. That's all.
All right, your name, please?
M.H. Ali on behalf of Mr. Esahad.
Mr. M.H. Ali, Learned Counsel, appearing in this case as a proxy for Mr. A. Sahad, Learned Counsel for the petitioner, submits that there have been some subsequent developments which are required to be brought on record of this case by filing additional affidavit, and therefore hearing of this matter be adjourned for 4 weeks. Mr. B. Sharma, Learned CGC, representing the respondents, is present and does not have any objection if the prayer is allowed. Full stop. This is a case of removal from service. Full stop. The matter pertains to year 2016. Full stop. However, since the petitioner's counsel is himself, since the Read petitioner is himself seeking deferment of the hearing of this read petition. This court is left with no option. No, deferment of the hearing of the read petition on the grounds stated herein above. This court is left with no option but to grant the prayer for adjournment. The registry to therefore list this case again for hearing after the additional affidavit on behalf of the petitioner is brought on record.
Lordship, highly obliged.
Obliged.
Timing matters, item 8.
May it please your lordship.
Yes, you have said. So what, they joined in 2001.
But my lord, their appointment letter is from 2000, that is page number. Appointment letter,
Page number,
page number 49 of that read petition, my lord.
page number 49.
No, my lord. Page. Appointment letter is from 2015, my lord. That is page number. Appointment letter dated 66 from 66, my lord. 69, my lord. One of the read petitioner is Sandeep Kumar. 69 of the read petition. Provisional appointment letter of dated 28 May 2015, my lord.
How many petitioners are there? They're all similarly situated.
All, yes, ma'am. Yes, ma'am. 6.
Yes, but then their appointment, initial appointment was in 2021.
2001, but subject to the conformity of medical board, my lord. That is, there is a, kindly see page number 4 of my.
That's right. So medical board's decision has been overturned by the High Court.
Yes, my lord, but
Then
that, my lord, after that they have appointed, my lord, as per High Court order, my lord. The appointment letter has been issued, my lord, as per the High Court order. But there is some provision, my lord, that is in page number.
no, we
Yes.
clarify that their initial appointment would be treated as so and so.
Yes, 2001.
And the break in service having been interdicted by the High Court.
Yes.
The ground on which they were discharged cannot be held to be valid. Therefore, the consequential action will be taken accordingly. That's all we'll clarify. Was there another recruitment process initiated after the High Court order?
No, my lord, that is on the basis of that initial recruitment.
That's right.
That
So
is
in between whatever has happened,
yes, my
the
lord.
High Court has held that it is illegal.
Yes, ma'am.
So
But there is no such direction as regarding the date of appointment, my lord.
that's why we clarify it. That their initial appointment entry into service will be treated as such and such date.
But my lord, there is a provision of taking oath, my lord, from the date of appointment, my lord. That is page number, relevant portion of that Assam Rifle Rule, page number 16 of my affidavit in opposition, my lord.
Page number 16.
16, my lord. The time of appointment, they have to take the oath, my lord.
No, you tell me one thing. The issue here is whether they will be governed by the old pension or new pension. Is that the issue here?
Yes, from 2005 new pension.
When did the new pension come into effect?
It is coming 2005, 4 and 4.
Huh?
2004. 4 and 5. 2004, man. 1/1/2004.
So persons appointed after 1/1/2004
Hmm.
would be covered by the new pension scheme.
Yes, ma'am.
All right. Now, for this post, appointment is treated as the date of initial joining or after completion of training.
After completion of training.
Where is that rules?
Malad, kindly see that page number 19, Malad. There was an undertaking of the petitioner. Malad. Page number 19 of my affidavit in opposition, Malad. Here, Malad, that undertaking has to be given by the petitioner. Malad, certified that I am aware about the fact that in case my being found unfit to be become an efficient
Oh, Mr.
soldier.
Majumdar, she has not understood the query and she will in all probably not be able to address the court. Mike, can you please help a little?
The system, what I understood was this. The person is enrolled after the recruitment rally, subject to final medical fitness and completion of the training. Once the training is completed, they go for something which is called the sapat when they are enrolled into the.
That is a process of induction.
So now in these particular cases, if I remember correctly, during their initial training period, there were some medical difficulties found. They could not complete their training and they were discharged. We approached this honorable court, Malad, they were retained back in service. Those termination was held to be illegal and required to be reinstated. Now, Malad, the issue that she would perhaps have to explain is, once a person completes the training, where would the service start from? The date when he was initially recruited after the rally, or would his service only start after the completion of the training? That, my lord,
The appointment will date back to which date?
the enrollment actually starts from the date of the finishing of the training. But for service benefit, it is the first date of joining that they take for every other purpose, even for the purpose of pension. The first joining that they do.
That is initial enrollment.
Initial enrollment.
There must be some rule to.
Yes, there is.
Which is that rule?
Malad, I'll produce the rule, but in kindly see in page number 19, I do not enjoy any privilege of the government servant till.
These are nothing. Don't waste your time.
Yes, ma'am.
We'll go by the rules.
Yes, ma'am.
If the rule says that these are all process, but once he completes, the person completes it,
yes, ma'am.
his entry into service will be treated from which date?
Yes, ma'am.
If there is something against this,
yes, ma'am.
Then the writ petition will be dismissed.
Yes, ma'am.
If there is nothing, then the
Then
writ
it will
petition will
be
be.
treated from 2001, ma'am. I'll got the I'll produce. I got the point, ma'am.
So when will you produce?
Malad, after PU, immediately after reopening of PU. Malad, give a date, madam.
Yes, yes. It is what everybody wants, no?
On 25th, Malad, Thursday. 25th, Malad.
Yes. So and so for the petitioner on the request of Ms. A. Gain, Land CGC, that this matter be listed again on 25/1/2024, so as to enable her to obtain specific instruction and appraise this court as to the provision of the rule regarding date of entry in service of similarly situated persons as the writ petitioner.
I can check.
So Ms. S. Bora for petitioner. Last it.
May I please, madam? Here the petitioners, they had participated in a selection process in the year 2012, which was initiated in the 2012 by an advertisement. 2013, my lord, the select list came out. The petitioner's name were not there. They filed a writ petition before the Honorable High Court at Punjab and Haryana, my lord. Now, there the response took a stand. Our case was, before that court was, that the number of vacancies which were supposed to be allotted for the state of Haryana was not disclosed initially. We had enough merit. They took in only 4 candidates whereas 176 posts were left vacant.
What posts are this?
My lord, these are posts of constable clerk, my lord. Head constable clerk in the Assam Rifles. Now, my lord, there they took a stand that while giving the state quota as per the total number of vacancies, the state quota which was being given was on the basis of their SOP of 2015. Recruitment being held in 2012, 15 could not have applied. And the Punjab and Haryana High Court held that want of territorial jurisdiction, you have to go back to Assam and file the case. We are now before this honorable court. Here they have filed an affidavit saying that per 2010 SOP, 2.09% of the post was to be granted for the state of Haryana. Calculation would show that it comes to 6 posts. This all has been recorded in the earlier order of this honorable court, where it has been recorded that the affidavit filed is shoddy. There is no revelation of the marks I have scored, the marks scored by the last select candidate, or how the vacancies were calculated. Now, in that absence, perhaps they will have to bring on the records. Otherwise, my lord, mathematically, they are wrong. And they have to give 2 more posts for the state of Haryana, where I will come in into the appointment process. May I just show that, my lord, if lordship will kindly have.
Just 1 minute.
Calculation of the frequencies, 82 issue. I am saying 8 posts. You are saying 4 posts. 8 hole I mean. I will be. 6 of me. 6 hole mine. 8 na lage. Maybe calculation too. 22.
Petition.
Your affidavit of wish. That calculation comes like.
Page 1/4.
1/4. Some rifles recruitment will be headed Jorhat from 10 December onwards for enrollment of 356 vacancy.
Your clients belong to the
Hawaldar clerk.
general category.
My lord, we are OBC category candidate, but we have not availed any relaxation, so we can be considered both for the general and the OBC category. Wherever.
So anybody scoring lesser mark than the petitioner has been appointed?
My lord, they have not revealed our marks. That is the whole difficulty. That is what is recorded in the earlier order also. They did not reveal our marks. That is 1. Number 2, when they calculate the vacancies for the particular state of Haryana, initially they tried to say that 2015 circular, it was 60% and therefore it is 4 posts. We point out to the court, no, it is 2013 really. Cannot be 2015 circular. Then they come up with the 2010 circular. For the 10 circular also, it is 6 posts. for the state of Haryana, even if you go by what they are trying to say. Their assertion that it has to be restricted to 4 is therefore gone, my lord. Therefore, more posts will come in for the state of Haryana.
And then how many petitioners are there?
3 petitioners.
One will not get it.
Maybe one will not get it, but they have accommodated 2 more persons after that 4. So from 6, it will come up to 8 if they want to accommodate.
But are these 2 persons parties in the writ petition?
The other selected persons, my lord. My lord, selected persons, so far as our contention was in the writ petition, that it will not be necessary because they are not divulging the method in which the vacancies were to be calculated. Number 1. Number 2, we are not against them. The number of vacancies, if it increases for our calculation, then we get a chance to participate for those vacancies if we've got lesser mark. Even in their affidavit in opposition, they have taken a stand that they will not be necessary parties and should not be implemented, is their stand in the affidavit in opposition. May I just read that paragraph, my lord? They don't want them to be parties. That is how they take up. When I make a plea that they are proper parties, stand of the respondent, nothing will.
Which is the right of the petitioner which has been violated?
My lord, had the number of posts been properly calculated, there would be 4 more posts.
So these posts are required to be apportioned.
Apportioned.
Where does it say that it will be done?
It will be done. Lordship will kindly have their affidavit in opposition at page 23.
No, you show from your materials, where does the court come to a conclusion that there was a requirement and the rules to apportion the post?
Yes, but we had filed the petition saying that 320th number of posts, prepare one select list throughout India and give it according to merit. They take a stand that the SOP requires apportionment. So when the SOP requires an apportionment, we have to go by their stand now. My stand that it should be on an all India basis and you cannot divide it between states, bringing in to allow it to particular states. For their SOP have not challenged it, it will have to stand then. That SOP will have to remain. In that SOP, they say that this is how we calculate it per state at page 23.
Any interim order passed in this case when you filed the petition?
Post vacant, the posts are kept vacant, my lord, in the force.
How many posts have been kept vacant?
3 persons were there, my lord.
So has anybody scoring lesser mark than the petitioners been appointed person to that selection process? And what is the validity of the select list?
Select list validity would remain, my lord, for a year, but since the matter is under litigation, the validity would continue, my lord.
Without even
It's
any
a
order?
merit list. What they did was they prepared a select list for 4 posts. Then in the next year, they added 2 more candidates to that select list.
But have they filled up all the posts minus these 3?
No, 176 were vacant when the petition was filed.
And now this 176 has been filled up.
My lord, we have 3 posts kept vacant, my lord. Other 173 they might have filled up. I do not know that.
Yes, what is your instruction, Ms. Guy?
That is, I don't have a reason whether that has been filled up or not, my lord.
Then you call your officer to come with the records.
Yes, my lord.
On 25th.
On 25th, my lord, same day.
If lordship, they can show that the calculation of vacancies
Yes,
was correct, I would be on a slippery ground. But if the calculation they have tried to show for 2015 first, which was totally wrong, 2010, it does not match. Then they are showing wrong records to the court. They are wrong statements in the court.
You call someone conversant with this matter to come.
Yes, my lord. 25th, my lord, same day on 25th, my lord.
Mr. R. Majumdar, Learned Counsel has appeared for the writ petitioner. B.C. Gayan, Learned CGC has appeared for the respondents and seeks posting of this matter again on 25/1/2024, so as to enable her to produce the relevant records, departmental records, so as to substantiate the stand of the respondents taken in the counter affidavit.
Yes.
Prayer allowed, register to list this matter again on 25/1/2024 as a fixed item. You call someone who is conversant
Yes, my
because
lord.
there will be a lot of questions.
Yes, my lord, that is calculation also regarding
And
calculation.
how much they've scored,
Yes, my
how
lord.
many vacancies you have filled up,
And what
when have you
legal,
filled up,
Who was the lesser,
He is the last person.
last
what
person?
cut off
one?
mark. All these he has to
Yes,
get it.
ma'am, I'll notice all.
Interim continues.
Interim order passed earlier.